May it please the court, my name is Elisa Smith and I represent Alexander Agreda. The facts in this case are simple, but the implications for cautious drivers' Fourth Amendment rights are significant. The trial judge's order denying Mr. Agreda's motion to suppress evidence should be reversed for two reasons. First, the trial judge erred in determining as a matter of law that driving 20 miles per hour under the speed limit, but within the minimum and maximum range of speed, justified a stop under the police community caretaking function was wrong. Second, the order should also not be upheld under the theory that the trial judge reached the right conclusion for the wrong reason because the officer did not have reasonable suspicion to stop the car for impeding traffic. First, the trial judge's factual findings do not support the legal conclusion that a reasonable person would have believed that either the driver or the occupants of the Agreda vehicle were in need of medical help or help in any way. The trial judge's legal conclusion also violates the limitations expressed by the Supreme Court in Katie versus Dombrowski in creating this police community caretaking exception. The Katie court required that this exception
Ms. Smith, before you get into the case law,
yes.
help me with the facts so I have a better vision of this thing. I know I have a car going 45 miles an hour roughly on US 27 going south, and this is 4 lanes, so there's a lane to the left of this car that people can drive around?
Yes, it's a 4-lane highway. There's a median in the middle, so there's 2 lanes going north, 2 lanes going south. It's posted 65 miles per hour. There is no minimum posted speed on the highway, but by statute, the minimum speed on this road is 40 miles per hour. The Agreda vehicle is in the far right lane, traveling 45 miles an hour.
Do we know anything about the vehicle itself, how old it is or what it looks like or anything of that sort?
No. The entirety of the basis for the stop was that the car was driving 45 miles an hour in a 65 mile an hour zone, and that there were 5 cars behind it, driving behind it. And so the police officer was sitting in the median.
Well, can I just interrupt you because I just want to make sure I understand what Judge Cowden did. In conjunction with everything you just said, which is consistent with cases where the motion to suppress was affirmed or granted, the judge found there was a medical concern of the occupants of the vehicle by the trooper. And that was a distinguishing feature between the cases that would favor the outcome you seek versus the judge's order being upheld. Can you tell me why that is something we can't take account of?
Yes, Your Honor. In all of the cases where, first, I guess I'd like to answer the question this way, is that there is not a single case in the state of Florida or outside the state of Florida that has held slow but lawful driving was a sufficient basis to raise concern of medical, someone that's in need of help or a medical concern for the driver or occupant of the car. In all, I'm sorry.
No, go ahead.
In all of the cases, slow driving may be a factor, but it's not the bright line factor. And in fact, in this instance,
well, the judge is trying to tether the slow driving to distinguish it with this medical concern, because that's what the officer said. Nobody goes that slow on that particular stretch of highway. They're always going at least 15, 20 miles above the limit. So if I see someone going that slow, even though it's within the limit,
right,
I get concerned that maybe there's something wrong. Now, maybe that wasn't plausible, but if the judge bought it, do we get to overrule the judge? That's where I'm coming from.
Right, and I believe that we have not challenged the factual findings made by the trial court. We're challenging the legal conclusions drawn from those factual findings. That it's our argument that suggesting that someone who's driving a lawful speed, a cautious driver, should not be stopped because they're driving within the lawful speed limit, particularly on Highway 27, where the trial court does make a factual finding based upon Officer Gunter's testimony that most people speed on this road. It sort of turns the law on its head that because people are exceeding the speed limit, that someone who's driving within the speed limit now raises a concern.
Did the officer have any factor other than the 45-mile-an-hour driving to cause him or her to believe that this person might be medically impaired?
No, not a single.
The officer's first assertion was that he stopped the car because the officer said it was impeding traffic.
Yes, Your
The
Honor.
officer did not say, I had a medical concern until he was sort of led into it on examination in the hearing.
Yes, but in the interest of full disclosure, when I went back and read the probable cause affidavit, the police officer does write in his probable cause affidavit that he originally stopped for impeding
Right.
or medical concern. And because I saw that in the probable cause affidavit, I'm not challenging the motivations of the officer
Right,
because I
well,
think it's difficult.
You can't really, but
Right. And so if it wasn't in the probable cause affidavit, though, I probably would have, because I do think that during the testimony,
the
he was...
transcript reads, he's sort of led into
He was led into it. And the trial judge did not find that this was justified based upon reasonable suspicion that the Agreda car was an impediment to driving. She exclusively found that this was justified under this kind of community caretaking.
The judge found in her order that solely based on the driving that far below the speed limit, it was objectively reasonable for the officer to stop the car. And she didn't say stop the car because of the fear of a medical problem, but that's clearly implied in it.
I believe that is the implication.
So the question is then, Judge Lanny asked, are we bound by the assertion that it is objectively reasonable?
No, I think that's a legal conclusion. I think it's similar to consent cases, that we're accepting the facts, but the question becomes, is this a reasonable conclusion to draw from these facts? And our argument is no. In fact, our argument is no with a policy concern. And that if this court holds that individuals who are driving lawfully, this is not a case, there are several cases outside the state of Florida, New Jersey versus Martinez, I think Ortega versus Texas, and there's one other one that's escaping me, Reinhardt out of South Dakota, where the individuals were traveling abnormally or excessively slowly in those cases. And that, even in those cases, it wasn't the only factor, but that was a legitimate basis. So someone's driving half the speed limit, or as the Martinez court was quoted as saying, at a snail's pace, 10 miles an hour, creeping along. And those are the only cases that I found that even remotely suggested slow driving, but in that instance it was abnormally slow, not cautious driving within the minimum and maximum speeds. I mean, the minimum speed on this highway is 40 miles an hour. If this court approves the trial judge's conclusion and the argument being made by opposing counsel that somehow someone driving within the minimum maximum speed with nothing else, no weaving, no lane change, no pulling off, no hazards lights, all those other...
There was no testimony about speeding up and slowing down.
No erratic driving, exactly, which is, the Florida Supreme Court in Bailey has held weaving and slow driving was sufficient. This court in DeShong and Brown has found that if there's erratic driving, slowing down to 30, speeding up to 55, and so forth. And apparently in Shively, he was unable to get a coin in the meter at the Channelside parking garage.
Don't we have to establish a bright line test saying exactly what you said to reverse the trial court, saying as a matter of law, that's not probable cause to pull someone over. You can't ever factor in medical necessity because that person's going within the minimum and maximum speed limit?
No, Your Honor, we're not asking for a bright line test. In fact, we're asking for the opposite. Our suggestion is that what opposing counsel is asking for and what the trial court found was a bright line test, because the only factor that was relied upon by the trial court was that this individual is driving 45 miles an hour in a 65 mile an hour zone. The other problem under Katie versus Dombrowski, first of all, this exception, when created by the Supreme Court of the United States, it was supposed to be narrowly and cautiously construed and applied. This is not narrow and this is not
You still have to have articulable facts to support a suspicion.
Right, under the totality.
To support a reasonable suspicion, not just a speculation.
Absolutely, you have to have reasonable suspicion that there was a medical concern, or that there was a concern of either the driver, the occupants, or public safety. A lot of these are almost DUI type cases where people are swerving and weaving.
It's not a lesser test than you have for suspecting criminal activity.
No, as a matter of fact, the other concern in this case is that the trial court's legal conclusion actually violates another restriction espoused in Katie, and that is this reasonable medical concern cannot be based upon hypothesized, generalized, or speculated concerns about safety.
In this case, my impression is the officer did not pull alongside of the car to look at the driver to see if the driver looked impaired. Is that correct?
Correct. There is no testimony in this record at all.
Followed for half a mile or something like that?
Yes, which I actually think is very interesting because it leads to the reason that I do not believe this should be upheld on the alternate ground. Because what this officer did, he was sitting in the median, he pulled onto the highway and obviously successfully passed those 5 cars to get behind Mr. Agreda's vehicle to pace him.
This car's being driven by
a woman.
A woman with an outstanding warrant or a bad license or something like that.
Right, which they didn't, of course, find until after the
It goes
stop.
downhill after they asked for the driver's license,
Right.
apparently.
Well, Officer Gunter is also an
Do we
interdiction.
know how old this driver is? If you were just...
The female driver?
Yes.
I have no idea.
Okay.
And my client was the front seat passenger. Officer Gunter is a drug interdiction agent, so he was sitting on the in the median. Perhaps Highway 27 is a large area, an area where there's a lot of drugs interdicting. I have no idea. But he stopped this car, he said, because it was driving slowly. There were no cars in the left-hand lane. The cars traveling behind the Agreda vehicle could have easily gotten over. There's
With the drugs.
or maybe they were all together. I have no idea.
A caravan.
It's going the wrong direction.
Right.
Yeah.
that's true.
Oh, is it? I don't know. I just.
We see a lot of cases.
Oh, do you? So, you know, I think that the policy concern here is significant. I mean, it's a simple case. It's an easy case. I venture to say it may be a fun case. But it's a serious case because there's a net widening effect. If this court does uphold a traffic stop of a lawful speed, you know, the statute sets the minimum speed on this road at 40. So someone's driving 45 miles an hour, and that's a justification for stopping an individual. Police officers can now use this as a pretext. They can, of course, stop people who are exceeding the speed limit on Highway 27. They can stop people who are going abnormally slow under the minimum speed. And now they can stop individuals who are traveling within the speed limit. It almost suggests that individuals can only avoid being stopped by the police if they drive exactly 65 miles per hour on the highway. And I would urge this court to reverse the trial court's ruling and find that it is neither justified, this one factor does not justify a medical concern, nor was the evidence sufficient to show that the Agreda vehicle impeded traffic, because it did not. Thank you.
Thank you. Save you 5 minutes for rebuttal. Mr. Hurley.
May it please the court, Jonathan Hurley, representing the appellee in this case, the state of Florida. Your Honor, the trial court cited Bailey and cited this court's decision in Brown, also Scheibe. And the key issue that Bailey focuses on and that this court focused on, relying on Bailey, was the unusual manner that the vehicle was being operated in, based on the totality of the circumstances. Okay, so looking at the facts of this case, you know, we detach ourselves from any reasonable suspicion that or probable cause that a traffic violation is occurring. We detach ourselves from that. Now, under the community caretaking function, what we're looking at in that context is whether or not the stop was justified for safety reasons, not for suspicion reasons.
Okay, well, let's stop right there. There is nothing unsafe about the way this car was being operated, was there? The officer didn't identify any such safety concern.
He did. And, well, the fact that it was being operated in an unusual manner, that was his concern.
That's unsafe.
Well,
He didn't say that was unsafe. What about that makes it unsafe?
Because people can pull right around this car, apparently.
yeah, well, because he testified it's impeding traffic.
But it was not.
This was
that's an assertion of law, is it not, for purposes of the statute? I don't see how anyone can, driving within the speed range set by statute in the right lane of a two-lane same direction situation can be said to be impeding traffic.
Well, I think it's based on the conditions. If it's late at night, if it's a bumpy road, if there's weather is foul, maybe that assertion is correct. In this context, you've got a beautiful day.
These cars can pull right around and go around.
This is Highlands County. Wintertime, we got lots of old folks living in Highlands County, and 45 miles an hour might seem just fine on US 27 if you're 90 years old. Is that against the law? Do you have to talk to a highway patrolman or?
No, I think we can use our own driving experiences and being on the highways when a car is going 20, 30 miles below the flow of traffic. We've all been there. How that can impede. How that can impede.
There's no cars in the left lane.
No, but there's 5 cars behind them,
Right.
including
And
2
they seem to be-
semi-tractors.
And they, for all we know, they seem to be perfectly satisfied because they're not going around it.
Well,
Because this is a situation where the legislature has set the minimum speed limit. The driver
I
who knows
understand
the law
that.
knows I have the right to drive 41 miles an hour on US 27. 'cause
but
I
again,
can't.
I think you need to change your paradigm. We're not looking at whether or not this was a traffic violation. We're looking at the community caretaking, whether the...
Under Wren, if we were looking at a violation, we would not be questioning the officer's motives in terms of pretext, right? There's
Correct.
a violation or there's not. But under the community caretaking function, it gets a lot fuzzier. And it seems to me that the vigilance against pretext becomes all the more important, does it not?
Again, I'm going back to Bailey and what the Supreme Court of Florida said. It's the unusual operation, okay? That's what the Supreme Court of Florida said. That's what this court said in both Brown and Chavez. So taking, however you want to determine what unusual operation, this officer who has experience on this highway, he's out there all the time. In this officer's opinion, this was an unusual operation of this vehicle.
That standing alone forms the objective, reasonable basis for the stop.
For instance, in Bailey, yes, there was an issue, 45 miles an hour on a turnpike, okay? Here we've got 45 miles an hour on 27. There was weaving, but not in and out of the lane. I mean, he's weaving, and there's multiple cases where the weaving is like, come on.
The other factors that just concentrate on the speed.
I could argue that Bailey and some of the other cases where they cited there was not any weaving in and out of the lane, that basically we're just dealing with slow speed. I mean, there's not a lot of room to be weaving in the lane, and it's not, we're talking feet here. We're not going in and out of a lane. So,
Let me just for a moment, let me give you that the officer can pull this car over and walk up to the window, and when he walks up to the window, apparently he sees a perfectly healthy woman of no exceptional age. Other than to tell her, ma'am, you probably ought to speed up a little bit, why does he have a right to get her driver's license?
I'm sorry?
Why does he have a right to get her driver's license?
Well,
Because the medical emergency has been put to the side as soon as he sees this woman, right?
the record's not clear on that. I mean, all what's being challenged here is the actual stop at that point. So we don't, even the probable cause, we don't have a lot more in this record to challenge beyond that. So we're kind of, we're pinned in for what we got right here. But again, that's why I just want to focus on, if you look at Bailey, maybe the Florida Supreme Court could have been a little bit more clear on what is unusual operation, but there is evidence in the record, page 103, page 113, page 116, where the officer, says the speed was unusual for this section of the highway, so on and so forth. It's not normal for people to drive this way, this part of the highway. Again, reiterating the unusualness of the speed. You've got a car, this officer, again, is on this, patrolling this all the time. He has experience of what the usual operation of vehicles are in this particular stretch of the highway. He didn't feel it was usual based on this particular context. Again, not reasonable suspicion of a criminal activity, nor probable cause for a traffic violation, simply that this was unusual. He sees that this is unusual, and he stops it for community.
He observes that it's unusual.
Yeah.
Why did he bother then to clock the car if he thought there was a medical problem?
Well,
Why didn't he just pull it
there,
over?
again, there's two reasons. He's granted, he's looking at, is there a particular traffic violation? He has the officer also has he sees it's unusual. He has a duty as an officer to investigate the situation. So he's, maybe there would have been swerving,
In fact, both of his justifications, impeding traffic and concern about a medical condition, would have been observable without knowing the precise speed of the car, correct?
Of course, but this is a little bit of a Cheech and Chong situation. If you look at the probable cause, in fact,
those of you who don't know
in fact, the defendant admitted that he had a marijuana joint and tossed it out the window.
Right.
So what happened was somebody, the defendant at least, was smoking a joint in the car. They're going 45 miles an hour. There's 5 cars, including 2 semis behind them.
This officer knows anything about Cheech and Chong.
Well, you get my point, that it wasn't, based on the totality. It's a beautiful day. There's no reason for this car to be going 45 miles an hour with 2 semis and backing up he calls it a parade of vehicles behind this car.
Any of whom could have just pulled right around him in the left lane.
That goes, I think, to the issue of the tipsy coachman argument that the state presented earlier, and that was the violation of the traffic statute, the 316.1835, the impeding or blocking statute. But again, going back to what I think is a strong argument what the court found was that focusing on the unusual manner, and there's plenty of record testimony by the officer detailing why he thought it was unusual based on his experience and so forth.
Involving the operation of the car itself other than its speed. I mean, talk about the time of day, you can talk about whatever, but the only aspect of the car's operation that was unusual was the speed, correct? No weaving.
In the context of
no running onto the shoulder, no speeding up,
Correct.
slowing down.
But in the context of the conditions, if you look at some of the other case law out there, distinguishing features are that, a bumpy road, it's late at night. There's not a lot of case law out there on this in Florida, but so that's distinguished. And then the other distinguishing factor in Brown and Bailey is that there was some slight weaving within the lane. So I think the focus is the excessively slow speed in comparison to what is the normal flow of traffic. And I think that was what gave that officer the right to at least to be proactive to make sure that everything was okay, to do a brief stop to make sure that everything is okay. And of course, once you determine...
After he followed behind the car and clocked it.
For a half a mile, the officer, half a mile is not that, it's not that far, but he's doing part of his investigation. He's got to see, he's concerned, he's got to see what's going on with this car. Why is it so unusual? It's driving so slow. That is the reason. Are there any questions? Thank you.
Thank you.
Thank you, Mr. Early.
Ms. Smith?
I'm going to go look Cheech and Chong up on Wikipedia.
Just briefly, taken to its natural conclusion, the state's argument is that police officers would be able to rely on a hunch to justify a stop, because they say in their experience it's unusual to be driving in this way. Even though it's lawful, they can stop someone. Even though this is a community caretaking case, reasonable suspicion, the state has the burden here to show that there are reasonable, articulable facts that support a finding that there was a true medical concern. The Katie versus Dombrowski case, which did predate Wren, does say that police officers cannot use the community caretaking function as a pretext for other purposes. It must be completely divorced.
But yeah, and Wren, though, was in the context of a law violation, and so, established a bright line. There was reasonable cause to believe there was a law violation or there was
An
not.
objectively reasonable
Right.
basis for the stop.
And then, you can't say, well, officers generally let that go so that stopping, but when we get into the community caretaking function, you don't have those bright lines. So it becomes, I don't think Wren precludes a concern about pretext in that context.
No, absolutely not. And there are many cases in the state of Florida that talk about the community caretaking function, but none say that the state doesn't have the burden of showing specific facts that support that medical concern. And in this instance, the only fact relied upon as characterized as unusual was lawful driving. And that bright line is wrong under the totality of the circumstances test, and we urge the court to reverse the lower court's ruling and hold that driving within the lawful speed, cautious drivers should not be stopped in the state of Florida. Thank you.
Thank you.
Interesting.
Next case is Goodman versus Polk County.